In August of 2011, the Grace Foundation was given ownership of 32 horses by officials representing Wells Fargo Bank, Bank of America, and Lassen County in California. Was this transfer legal?
You be the judge.
Ladies and gentlemen of the jury, on August 26th, the Grace Foundation was given final disposition of the following horses and 2 goats. Here is the document confirming the transfer of title from the bank's receiver to the County of Lassen and then to the Grace Foundation.
Looks like an official document. What's the problem?
The final disposition agreement states that, pursuant to a court order dated July 29, 2011, the receiver to the property is authorized to turn over any and all animals residing at that location to the County of Lassen. However, the Grace Foundation later discovered that the July 29th order stipulated that the horses were to be turned over to the Lassen County Animal Control Facility, a specific division of Lassen County. Further, the order specified that any person who could show proof of ownership could have their horses returned to them, including their owner, Mr. Bennett. There were no provisions made in this order that allowed for the transfer of ownership to any other party. There were no additional rulings that took place after July 29th that would have authorized transfer of title to Lassen County or to the Grace Foundation or to any other party. Additionally, on August 18th, the owner of the horses filed for bankruptcy. All parties were made aware of the bankruptcy filing during a contempt of court hearing held on August 19th, except for the Grace Foundation, who was not a party to the case and had no reason to be present at the contempt of court hearing. The Grace Foundation was not told about the bankruptcy filing until early September, nearly 2 weeks after the horses had been given to the Grace Foundation.
Why does this matter?
The bankruptcy filing should have stopped the transfer of the horses from the property. The bankruptcy placed an automatic stay on Mr. Bennett's assets, including his horses. There's no way that the Grace Foundation could have been given ownership of these horses just 7 days later. The bank's attorney knew this, and he filed an ex parte motion requesting a temporary relief from stay on August 25th, just 1 day before the horses were given away. This motion was denied on September 2nd, forcing the bank's attorney to disclose the bankruptcy, the stay, and that the Grace Foundation did not have title to Mr. Bennett's horses after all. To summarize, the Grace Foundation was given ownership of 32 horses and not told that a judge's order stipulated that their owner, Mr. Bennett, could have these horses back. The Grace Foundation was also not told that Mr. Bennett filed for bankruptcy a full week before the transfer of ownership of the horses. His assets, including his horses, were protected under an automatic stay. The Grace Foundation was deliberately led to believe that Lassen County and the banks had the authority to give Mr. Bennett's horses away. Do you think the final disposition agreement was valid? Do you think the receiver, the banks, and Lassen County violated the July 29th order when they gave Mr. Bennett's horses away?
You be the judge.
Guilty.
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 Guilty.